because small claims in our national courts are not free procedures. Court fees must be paid, no? And there is an option which I remember was highly discussed during the negotiation for problems concerning privacy or something like that, because in the forms, in the Form A of the small claims, you can also write your bank details for be charged by the court fees. But basically, or at least in my country, nobody is confident with this method. Nobody wants to write his bank details on the form. No? Maybe in other countries it works, but in Italy not at all. So what happens? That once the Italian court receives the claim, the Italian court stops the proceedings because it asks for the money, it asks for the court fees, and he sends to the free agreement. He sends a letter claiming the money, the letter in Italian language, of course, claiming the money. So there is this misunderstanding, this problem to be solved by providing information on international bank transfer or international portal, electronic portal for payment by credit card or something like that. But this is a problem because otherwise proceedings are stopped if you don't pay court fees. Other problems raised in the practice, as for instance, the problem that Sandra was saying before, the problem of the fact that all the forms negotiated 6 years ago are not enough to complete all the communication between parties and courts. Small claims and order for payment are procedure based on a strict, narrow dialogue between courts and parts. No? But basically, as I showed you before, that communication coming from the Italian court was in a simple Italian letter, not in any form by the European Union. So we should discuss further about the effectiveness of these forms. Moreover, in the view of the European small claims, in the view of the European order for payment, the court should play the role of central clerk, central clerk for the parties. Parties must not communicate between them. Parties must communicate between the court says, which is called to send documents to the defender and the documents of the defender to the claimant. Actually, in Italy, but I think it's not only the case of Italy, claimant is called to serve the claim to the defender. But if you want to serve a claim to the defender, you must physically go to the court seized and ask for the local bailiff to serve the document to the defender. Not speaking about the problem of the language. This is another problem raised also by Alexander, because court does not translate documents or claims. So basically you are called to translate documents into the defender's language, and in some cases also in another language. Because think about when the court is located in member state A and the defender claimant in two different member states. So you have to translate in two different languages sometimes. All practical problems arising from this application. Very briefly, some solution for the future. I think, and I already said that many times, in order to improve the effectiveness of this regulation, three small suggestions, three small lines of action. First of all, I was talking with Sandra before, according to my opinion, if we let the value of 2,000 euro for this regulation will not improve anymore. We have to create cases, not only arising from consumers but also from companies. Because companies for outstanding credit before 2,000 euro just needs a signal, a letter by their lawyer, and they put this negative post in their balance. They do not go on the proceedings. It's a creditor lost with the letter of the lawyer, because the lawyer says this is not proportionated, now the costs with the value, and they solve the problem in this way. First of all, because moreover, there is also the problem of counterclaim. As a lawyer, if I want to stop the proceedings of the claimant, I immediately raise a counterclaim, because there is no harmonized notion of counterclaim, of how strict must be claim and counterclaim, and therefore I oblige the seized court to stop the European Small Claims Procedure and to apply the ordinary and Haber procedure. First of all. Secondly, interoperability. This is not juridical term, but it is a very important term, interoperability. So, in other words, all the actors involved in this procedure must cooperate. Not only judges, courts, but also clerks. By a more efficient use of the forms, and by use technological means. Me as a Minister of Justice, I'm appointed by the Italian Minister of Justice for the European very famous project called e-Codex. E-Codex, now we are creating a common technological platform in Europe for sending documents in all the European member countries in European civil proceedings. And that will be very important, because in this way we shall avoid in the next year, 2013, there is the final phase of this project. We can avoid foreign claimants to personally move or to appoint someone to do the activities of the seized court. The e-Codex project, which involves 40 member states, including Turkey, as non-member state, but future member state. And finally, dissemination. Dissemination of these rules, because basically, also in Italy, these rules are not very well known. And frankly speaking, I can say on this point that Commission should have used all the money budgeted for 2011, 2007, 2013 European civil justice for more and more programs of dissemination and of training of courts on these procedures. Because don't forget there was a lot of money, huge amount of money for this procedure. I stop here, and if you have any question, I prefer answer and not speaking so much. Thank you.
Thank you, Marco, for your presentation. And now I'm very, very pleased to give the floor to Professor Alexiou from the University this time.
Thank you very much, and thank you for inviting me here. It was a very challenging thing for me. I'm a graduate international law professor, and I knew about litigation, but first I asked my husband, who's a practicing lawyer and head of a law firm, what's new about it? Do you have any idea about this regulation? And he said, what regulation? That was the initial answer of the practice. I asked more people. I didn't find a lawyer who knew about it. Two, I asked my colleagues at the university, and I said, what do you think about this regulation? And they said, nothing, we don't like it. Third, I thought that I should check what the courts do. And since I couldn't find anything on the legal database we have in Greece, no published judgment, I did some research of my own in the biggest areas, Athens, Piraeus, and Thessaloniki. That covers more than half of the population of Greece. And I expected to find some cases there. None. It's astonishing. But it looks as if this regulation has been totally ignored in my country. So that's why I said it's a challenge. I wanted to listen what other countries have to say about it. And I must say that the last speaker usually is the unlucky one, because most of the issues that he or she would like to cover have been already covered. This is good. I won't tire you much. For example, what I heard about Spain, what I heard about France, Italy, is more or less same problems to us. So I will just telegraphically mention some of the issues. Of course, I must state that in Greece we have a small claims litigation, but the sum is 5,000 euros. It's not as small as 2,000 euros. And those claims are heard by the justice of the peace. We have plenty of justices of the peace who, of course, do not know about the regulation. Now, let's take Form A. It contains certain concepts and notions that we doubt. And what I say, it's not my own opinion. I have discussed it with colleagues and practitioners. We doubt whether any layman who is not a lawyer could successfully fill the form, because will the non-lawyer fill the form himself? If he does, he won't understand those concepts, like what is the place of performance, one example. And if he asks for the help of a lawyer, he will have to pay. It won't be as cheap as we think. Then, what about the consumer? I heard a lot about consumers here. Our impression in Greece is that it will not be the consumer who will be the claimant. Most of the times it will be the other way around. It will be big companies, or smaller companies, but more organized than the consumer, who will sue the consumer for small claims. So this regulation doesn't seem to us to protect the consumer very much. It will press the consumers more. And many of them will prefer to settle outside the court than get involved in trans-border proceedings, which I think that they are afraid of. We found that in Finland they have stated that all such claims will be heard by the first instance court of Helsinki. We discussed the possibility of having the same in Greece. I don't know if that can ever happen, given the situation of the many justices of the peace we have around the country. Service is a problem, because we have new rules of civil procedure added to our Code of Civil Procedure, but still the rules on electronic means of service are pending, if I'm not wrong, and so we don't have any news about that. Practical assistance provided by Article 11 for filling the forms and informing the parties about the procedural aspects. It's quite problematic. It seems problematic to us as regards the practicability. The economic advantage of the parties who don't want to pay a lawyer may become a big burden for the courts. And we don't know if the judges will want to take that burden on their shoulders. Because if they have to assist the parties, that's a time-consuming process. They are already burdened a lot. They constantly claim they have to have more judges. So I don't know if this will work in our country. Then there's another thing provided by our Constitution, the publicity of the proceedings. If we have all that in writing, this may create problems according to our Constitution, because there will be no publicity with this exchange of documents. Also, the regulation does not provide for complex litigation. Form A may be used for the claim itself, but not for other purposes, such as, for example, an intervention of another party. And this leads to the exclusion of third parties from the proceedings, even when their participation may be necessary. For example, the intervention of an insurance company in a lawsuit for damages in a car accident. Now I will come to the question of applicable law, which was the first that intrigued me, being a private international law lawyer, and I said, what, for example, if the parties have agreed, according to Rome 1, about the applicable law, what happens? What law will the court apply? Because the regulation seems to be the merry-go-round of the lex fori. Okay, but that's for procedural issues. What about substantive issues of applicable law? That's a big problem. Then we have another issue of constitutionality. In Greek law, the discretion of the court to ask the plaintiff to withdraw the claim, if it's unfounded or anything, raises issues of constitutionality because it violates the right to legal protection and amounts to a procedural pressure to the plaintiff to withdraw his claim. Another point, Article 4, paragraph 4a does not distinguish between manifestly unfounded and inadmissible suits. So the court must use form B. However, the wording of this form is adequate only when the court requests the completion or correction of information. Does that mean that the judgment will be needed without the use of form B? There is no provision regarding the right of the claimant, plaintiff, to reply to the allegations of the defendant. This is a problem for us, especially if the defendant raises objections. The plaintiff is deprived of his constitutional right for counter-evidence or comments on the evidence presented by the other party. Then, of course, I will agree about the language problem. If you come from a country where English is easily learned, like in the Netherlands, for example, that problem does not appear very strong. But although in Greece, most young people now speak English, more or less, still, can the parties handle documents and forms in a foreign language without the assistance of lawyers? Maybe this is one of the reasons that our lawyers are not interested in this regulation, because if it worked, they would have to lose much of their business. But practice shows they won't, because the parties, in Greece at least, do not trust themselves. They feel that they do need assistance for legal issues, and language makes that assistance more necessary. And of course, talking about enforcement, and I close with that, public policy is also a big issue. And although public policy, as we all know, has been compressed to specific issues nowadays, it's not what it used to be, still, in enforcement proceedings, in this regulation, it may be a problem we have to overcome. So all in all, the situation in Greece right now is a desert in this area, and the prospects, if nothing changes, seem rather bleak. People prefer to use the regular ways than use the regulation. As I said, no case exists. We have to wait and see, but I'm not very optimistic. Thank you very much.
Thank you all for your excellent presentation and for respecting the time. I really appreciate it. Now I have. so sorry.
There were two of us.
No, okay. Thank you. I think it's time now for a question or for comment. So I will give for us.
Well, I do have a small point on Professor Anastasia's comment that there's no application of the small claims regulation in Greece, and I think it's not the fault of the Greek courts or the Greek people, because the regulation is a cross-border small claims litigation, and it is for the foreign nationals of the other European states that to apply the regulation if they have any claim in Greece against the Greek national or Greek companies. Which means that either there is no...
Early in the Netherlands we found it, it's often a Dutch consumer that brings a claim, for example, to a foreign airline.
Yeah.
So it is both ways.
It is both ways, but I believe the regulation is mostly applied in Italy. I think mostly and some other countries, mostly from the other countries, to file an action to Greece against the Greek companies or Greek nationals, if I'm not mistaken. That is interesting. That why we don't see that type of actions in Greece. It's not only Greek people that is going to apply the regulation, also the foreign nationals in other countries. That's quite interesting for me.
This is correct, if I may so, because of course the sample of the Greeks using the regulation shows nothing.
Oh,
but
I think
also
there's
foreigners using it, as you mentioned.
There's an interesting question there as well, because you said that the Greeks prefer the regular way. And then the question becomes, in what way is the regular way better for the Greeks? So there's an additional area of studies. And listening to all of you, I was thinking, well, maybe the European small claims procedure is good for some people, because it is used, so there must be a use for it. But maybe one of the things which you could try to do is to individualize the cases, the sort of cases for whom it is good, and also the sort of people. Maybe the small claims procedure is better for businesses. I heard several suggestions this morning, and maybe it's not so good for consumers. Maybe the European small claims procedure doesn't decide for whom it is concerned. I think it is an issue which is present in the establishment of all the small claims procedures and small claims courts. For whom is it intended? In Canada it was also the case. In the beginning, first in the 70s, when the small claims procedure was established, there was a suggestion that it was only for consumers. But is that feasible? Maybe that is not at all feasible. One of the characteristics of the small claims procedure in Canada is that it is flexible. And here we heard suggestions that there should be a harmonization of procedural law, to start with the question of the counterclaims. Why do you need a standardization if the issue of the small claims procedure is exactly to be flexible with forms? So I think there's a lot of issues that we can further discuss.
I think that they tried to settle a specific form in order to create a mutual trust between jurisdictions, because there was the problem of course, the older member states and the newer member states, and about the judiciary and all kinds of details about the legal systems of the new member states is not available in English, French, or other languages that are widely speaking in the European Union. So mostly we find text just in the language of the country, so it's not so much known. And I'll give you an example this week at the presentation about the Polish system. Professor thought that for all the European Eastern countries, there is no actual database with the decisions of the court, which of course is not true. So there are a lot of missing elements of knowing about each other's judicial networks. So maybe creating a certain format helps securing certain standards or securing certain elements that would lead to a good decision.
Can
can I follow your interesting consideration? Because I remember that the setup of these forms, no, 6 years ago, took several meetings at the Council of the European Union. So people from all the European member countries went to Brussels to discuss each line of these forms. And I am deceived and disappointed that these forms practically did not work in the practice. I think that the problem of the translation, in some sense, of the forms and of the documents must be an affair, must be a problem of the court system. We have to implement some systems in the national courts in order to solve this problem. Because we don't have to forget that in Brussels the approach is for the multilingualism perfect, no? So basically, you can translate everything. But be careful, because you know, we are jurists, no? So we do not have to forget that juridical vocabulary is a very technical one, no? Wordings, terms cannot be translated automatically, no? You have to be very careful. There is that point number 8, no? Famous point number 8 in the form A, where the claimant must describe, no, the facts of what happened. And on that issue, several discussions took place in Brussels, because this is the sole part where the claimant must fulfill autonomously, no? Not providing with the automatic translator of the atlas, no? The judicial atlas. So this is a problem, because I think we have to solve on the court system by implementing a system in the court system. We cannot leave the claimant translating on its own, and we cannot give excessive belief on the software of the atlas, no, or judicial atlas. Because later, problem of misunderstanding, interpretation can be raised by the court system. That is my impression, no, of the problem.
That's also what our court said in the Netherlands, that first there's the issue of a natural person being very, not always being capable, or in many cases not being able to give a legal assessment in the first place, and of course the regulation doesn't require that, but it should be a consistent story. You cannot say, well, this happened and he was rude and then that, and okay, now please give me the money. So that it has to be a consistent story in the first place, and then you have the translation part. So that's a two-track problem. And in the Netherlands, they are not so very fond of forms. We have tried it in the lower courts to work completely with forms, and then it was basically abolished because the court said it doesn't work. You know, it doesn't work. People just write complete stories, and you cannot make something out of that. In the lower courts in the Netherlands, a lawyer is not necessary, because that would indeed be. But we do have service by a bailiff, and then the bailiff plays an important role to make sure that the documents that are being served are in order. You know, that they have basic information, such as the address of the defendant. That's also a finding that we had for the small claims. And sometimes even basic information on what the address of the defendant is misses. They don't even know, well, oh yeah, should I write an address? Of course, there's field that where you should fill it in, but nothing happens if you don't. And then in the second place, that the address is correct. And that's all basic information that is often lacking, and in normal Dutch procedures it would be the bailiff that does at least check this basic information. And that does cost some money, but if the claimant wins the case, then the defendant will have to pay for that. And that does work, at least in a domestic situation. That does make it very... But what I think, you know, there are a lot of problems, but I think the point of departure should be, we have cross-border cases, they do exist. And what is the alternative? Have a national case where we have all the problems as well, of case management problems and unfamiliarity, and maybe even worse, or have the European small claims procedure as an alternative that might improve over the years. And also, if I hear a lot of comments, and it all has to do with, indeed, national legal culture, with unfamiliarity, but this is something that's also what I've told the Commission that they were very disappointed that it has not been used so much. I said, come on, wait, you should push it forward, and it will take time. Maybe in 10 years we will conclude that it doesn't work. Well, then we have to think of something else. But don't be disappointed. It's a huge thing. It's a complete new procedure. You cannot expect in a couple of years that it's applied worldwide or European-wide and that it all works perfectly well. Also for a national procedure, it would take years to find its way into practice.
Commission had to evaluate it in 2014,
Yeah,
2 years.
I know. Yeah. Okay, but that will just be a first evaluation, and but I think the starting point should always be what is the alternative. We can say it's not good, but what is the alternative? Yeah, we go back to national procedures that are probably even worse. So that is.
Don't expect too much.
No. But I would also be fine if they say, well, it doesn't work. In the European Order for Payment procedure is something else. But that is simply because those are often B2B cases where a lot of money or more money is involved. So that's also commercially interesting for lawyers and whomever is involved. And small claims, even at a domestic level, will always be not the key core cases where the interests lie.
You are still implicated in, you are following from the Commission point of view?
The most current news I heard about the future of the small claims is that they are discussing about to upward the limit now to 2,000 euro, to 5,000 euro. This is one of the ideas on the work table, and basically Commission invested a lot on this European project for interoperability, no? So they do not want to change dramatically the text now, the regulation. They want to invest on the practical application, no? So to encourage the interoperability between the judiciary courts and to implement this electronic portal called Recolex, which will be basically the means of the method of submissions of claims starting from the next years. We hope now, because the pilot phase will start from September of this year, 2012. And there will be a sort of electronic portal in Europe, and the claimant from each member state shall submit its claim by lodging in this portal, this electronic portal. And so we are discussing a lot of problems concerning the identification of the user, the advanced signature, electronic signature, the problem of the acknowledgement of receipt, all the problems not arising from this portal. But this is the future, because if you want to allow practically entitled claimant to submit his claim from his house or from his office, you first of all you have to create a system in order for him to do it from his house, no? In some sense. And by providing on place a more efficient system. Another proposal on the work table is to indicate one centralized court in each member state dealing with all the cases concerning European order for payment and European small claims, in order also to avoid the problem to train all the judges, all the courts in each member state. Just choose one court and that's all. And you have to provide for an internal mechanism moving all the claims towards that national court. This is another proposal. It's not so difficult. Sometimes there is not.
Why did they not do that from the beginning?
Sorry.
Why did they not choose that solution from the beginning? So maybe it was a bargain there when they made it first.
It's infringing upon the national system.
So maybe it's a political behind.
Yes,
so they tried. Okay, we cannot interfere. We can common denominator, and then we will show that the results are very weak. So we push for
Well,
litigation.
international jurisdiction, that's within the competence, but national jurisdiction